संदीप.
हा कोल्हे सर.
हा, आवाज येतोय ना?
हो येतोय व्यवस्थित अगदी.
हो, ओके.
ओके ओके.
पिक्चर वगैरे क्लिअर माझा?
हो सर, थोडं असं अंधुक दिसते.
लाईट दिसतो का जास्त?
हा नाही, लाईट कमी आहे उलट थोडा.
बरं, ठीक आहे, ठीक.
प्रोग्रामला आहे, कार्यक्रम चालू होतोय. येतो विचारून चाललं. बापरे, आंबे कापते काय?
आणि घरी आला. अरे म्हणजे
मग तू आंघोळ कर ना आता पटकन.
हॅलो.
हा बोला
सुरू
साळुंके
करू.
सर.
नेते सर.
हा बोला.
हो.
सर सुरू करायचं का?
हो सुरू करा, सुरू करा.
साळुंके सर. साळुंके सर.
हो हो येतोय सर आवाज. बोला.
हा नाही
सुरू करा.
तुम्ही सुरू करा ना.
ओके ओके. वेलकम वेलकम वेलकम. Good morning all the dignitaries, excellencies, delegates, ladies and gentlemen. It gives me a great pleasure to extend you to a very warm welcome for the one-day national seminar on intellectual property rights. I am Dr. S.S. Salunke on behalf of the organizing committee. Welcome all of you to the one-day seminar. We are grateful to all the dignitaries on this digital dais who accepted our invitation to be the part of this elite event. I request our principal, Dr. J.B. Anjanesh sir, to occupy the chair of the president of this seminar. Thank you, sir, for accepting the request. Now I request Dr. K.G. Kolle sir, convener of this seminar, to come and address the preamble of the seminar.
Good morning, all dear friends. Am I audible?
Yes, sir.
I again heartily welcomes all the dignitaries and dear participants on the behalf of Ainpur Prasad Mandal and Sardar Vallabhbhai Patel Arts and Science College, Ainpur. Dear friends, our college is located at the bank of Tapti River in Raver Tehsil, is a remote and role plays. It's my great pleasure to introduce today's national seminar as a functional and applied for the researchers, authors, and inventors. Last year, we have organized a workshop on intellectual property rights for the faculties and students. Starting from this program, our management and principal encouraged us to organize this event on the national level. Our college has its asset of 14 PhD and about 6 MPhil faculties. Intellectual property is the creation of minds of an individual which is a commercial and moral value. Intellectual property rights grants exclusive rights to an author for utilizing and benefiting from their creation. There are different types of intellectual property rights: patent, copyright, trademarks, design, database, trade secret, etc. It includes the intellectual property management, just as the pending patents, infringement of patents, patent mapping with competitors, patents, etc. Our today's guest will go through details on the intellectual property rights for the valuable discussions. I hope with confidence that all these participants will enjoy this event, and this seminar opens a new dais for the intellectual property users, interested authors, and researchers. I hope all the participants will gain and enjoy again this event to increase their potentiality of individual one. Thanks to all dear friends, and I forward my this Zoom to Mr. Salunke.
Thank you, sir. Thank you.
Okay.
On this great occasion of the national seminar, I request our principal, Dr. J.B. Anjane, sir, to address us.
Thank you, Dr. Sandeep Sadonke. Good morning to all of you. It's a great pleasure to welcome you all on the behalf of Ainpur Parisar Shikshan Prasarak Mandal, Sardar Vallabhbhai Patel Arts and Science College, Ainpur, in this national seminar, Intellectual Property Rights Need and Awareness, organized by Knowledge Resource Center and IQSC. Dear participants, our college is established in June 1993 and successfully completed 27 years. In April 2019, our college is re-accredited by NAC with B grade. I am very much pleased to tell you all that our college runs 5 undergraduate courses, 3 postgraduate courses. Also, our physics, botany, and chemistry laboratories are recognized as research laboratories by Kavaitri Bainabai Chaudhary, North Maharashtra University, Jalgaon. College is located in a very remote area, in a small village, Ainpur, 70 kilometers away from district place Jalgaon. In this academic year, around 600 students are taking online education. Out of 30 teaching faculty, more than 50% teachers are PhD holders, and 10 teachers are research guides. Universities and public research institutions are among the direct contributors towards innovation and research, particularly in emerging economies. The potential pool of talent for innovation in these economies so emanates largely from educational institutes and research institutes. Of late, the significance of intellectual property rights in higher education has been widely recognized. This could be credited to the National Intellectual Property Rights Policy approved by the Union Cabinet in May 2016, which was the first ever IPR policy framed by the Government of India. The primary focus of this policy is towards promoting innovation and creativity, especially amongst entrepreneurs and in higher education institutes. The UGC, University Grant Commission, the nodal authority for determining and maintaining of standards of university education in India, issued a letter for inclusion of the intellectual property rights as a generic elective subject under the choice-based credit system, that is CBCS credit system. The National Institutional Ranking Framework, NIRF, a ranking system adopted by Ministry of MHRD, ranks institutes by considering IPR and patents, both published and granted by students and faculty members. Publications and patents applications have been found to be highest from engineering and technology institutions. Copyright, patents, trademarks, and trade secrets. These are the 4 types of IPs. Filing for intellectual property rights not only helps innovators protect their invention, but also provides better collaboration and funding opportunities. Most of the students, scholars, teachers, researchers, managers are not fully aware about the benefits of IP and other related issues. Today, our eminent speaker, Dr. Vikram Suvarnakar from DY Patil Institute of Technology, Pune, will guide us on the most important topic, need and awareness about intellectual property rights. I assure you all that you all will be introduced to a most important subject, IPR, and you will be enjoy the national seminar throughout the session. And at the end of this seminar, you will be leaving with a great smile and bagful knowledge of IPR need and awareness. Our management always encourages us to organize such programs. I am very much thankful to our Honorable President, Mr. Bhagwat Patil, Honorable Chairman, Mr. Sriram Patil, Honorable Secretary, Mr. Sanjay Patil, and all the members of Ainpur Parisar Shikshan Prasarak Mandal, Ainpur, for their kind support and valuable guidance. I am very much thankful to Mr. Dr. Vikram Suvarnakar for accepting our invitation as expert speaker on a topic IPR. With the support of our college staff, organizing committee, convener, coordinator, organizing secretary, I wish a very grand success for this national seminar. Thanks to all. Over to Mr. Sandeep Salunke.
Thank you, sir. Thank you for your kind motivation to organize such programs. Now I request Dr. S.N. Vaishnav sir, coordinator of this seminar, to introduce our today's resource person. Vaishnav sir.
Thank you, sir. Good morning to one and all. It's great pleasure for me to introduce today's keynote speaker, Honorable Dr. Vikram S. Suvarnakar, who has kindly agreed to speak to us on the topic intellectual property right. Honorable Dr. Vikram S. Suvarnakar has completed PhD in Mechanical Engineering from University of Rajasthan, M.Tech from Vidya Vikas Institute of Technology, Hyderabad, B.Tech in Mechanical Engineering from MIT Aurangabad. He is an articulate mechanical engineering with 13 years experience. Currently, he is working with Dr. D.Y. Patil Institute of Technology, Pimpri, Pune. Honorable Dr. Vikram S. Suvarnakar is owner of 17 patents relating to the mechanical engineering. Out of these, 6 patents are published and 4 patents are waiting for examination. Some of them are smart heat ventilation and air conditioning system for vehicle, GPS-based speed control of vehicle using generator cable, clutch pad wear indicator for vehicle, design and development of wind turbine for power generation. Sir has published 4 research papers in international journal having high impact factor. Some of them are indexed in Scopus. He has received a research funding 5.94 lakhs from AICTE under the scheme for development of mechatronics lab for the year 2018-19. Sir has published two books entitled Production Planning and Control for JNTU Hyderabad and Process Planning and Cost Estimate, Anna University, Tamil Nadu. He is the member of International Association of Engineers and Institute for Engineering Research and Publication. In order to get maximum time for keynote speaker, I introduce Honorable Dr. Vikram S. Suvarnakar in brief. Now I will hand over this to Dr. Sandeep Salunke.
Thank you, sir. Now it's time to move towards the technical session. I feel proud to invite keynote speaker of today's seminar, Professor Dr. Vikram S. Suvarnakar, sir, to deliver the keynote lecture.
Okay, thank you, sir. Thank you, Satish, sir. Thank you, Sandeep, sir, for this great introduction for me. And it's grateful for me also to have this introduction and to deliver the session on this IPR. This is what my passion. Okay, so I request our this technical team to give me this co-host so that I will share my slide.
Sir, you can share your slides.
Yes, yes. Sir. So just I get the confirmation whether my voice is audible and the screen is visible to everyone. Please, anyone of you,
Everything is okay, sir. Fine.
everything is okay. Okay, sir. Thank you. So the introduction is already there from my side. So I, Dr. Vikram Suvarnakar, I heartily welcome all the participants and my dear faculty members to this today's seminar on this overview on this intellectual property right. Okay. So before the starting of this session, I want to clear some points before starting. That points are, so what the things are I'm going to be covered in this today's seminar. Okay. So the I want to discuss. Firstly, I want to discuss this presentation would be of in the two part. The first part is the overview of the intellectual property rights, and the second half session would be on the how to file a IPR into this Indian patent law. Okay, so detailed procedure to filing a patent into Indian IPR. That is what the second session. So, and lastly, we will have a session on the if you have any query about this, how to filing, about the filing, about anything related to today's seminar, that we will have the session at the last. Correct. So moving forward in this, I will just start my presentation. Uh, every participant in today's seminar have something in mind. I know about that. That is what my trigger to go in deep in that in IPR. Everyone at least have an idea that I want to do something in the students' minds also. They have some unique idea in their mind, but the most important point is that we don't know how to put it that idea onto the paper and file a patent into the Indian Patent Office. Correct. This is every individual having the same problem. Even myself also, I go through that problem, and we know that there are so many these firms are there by which we can do this patenting also. But apart from that, if you want to file an individual patent into the patent office, that is what this today's lecture is all about. Correct. Then coming to the core part, that is the so what is intellectual property? So the two terms would be there, IP and the IPR. So here I will tell you the difference first about in between the IP and the IPR. Correct. Then what is intellectual property? Okay. we oftenly know about the properties related your house, land, and all. Correct. And what is the difference between this intellectual property and the property, the property, the word we known to us this is so many years about this land, flat, house, and all. Okay, that concept also I'm going to be clear. So the intellectual property is a something produced using a human intellect which has a commercial value. So this definition is given in this IPR section of this 21J. So intellectual property means it is going to be developed by the human intellect and which has a commercial value. So this is the intellectual property. And this intellectual property is often intangible in nature. So intangible in nature means it is not this imaginary one. Correct. But usually contain on a tangible or the fixed medium. Means if have I'm idea about this to develop something for the student or something for the society and something for the industry which has a commercial value, but that idea is intangible. Intangible means we cannot see or you cannot see the what the ideas are running in my mind. So this is called as the intangible, but usually contain a on a tangible or the fixed medium. Means that idea you have to make a model or you have to make one sim prototype or the working model so that you have to apply for the patent. Means the basically the intellectual property is having an intangible in nature but usually contain a tangible or the fixed medium paper. Like an example of this CD, computer chips, there are so many examples are there. Okay. Then the what is a intellectual property rights, that is the IPR, and what are the constraints of the IPR which gives you a protection for your patent. The intellectual property right. So you people not to be confused with the IP. IP means the intellectual property, and it is the right vested in the asset, not the asset itself. Are you understanding? It is it is not it is a right vested in the asset, not the asset itself. So the IPR gives you, sir, the protection for your invention, and itself it is not. You can say that it is not given this. It's like a asset and all. Okay, so for example, an idea or the invention, an idea or the invention is an the intellectual property. Correct. A patent registration is an IPR. Understood? A customer or a price list is a IP. That is the intellectual property. A right of confidentiality is an IPR. Okay, so IPR gives us a right of that maintaining the confidentiality of your intellectual property. And a secret production method is IP. So here in the example, I will cover the all or the parts of this intellectual property rights. A secret production method is a IP. That is what is called as the trade secret. A right to trade secret is an IPR. A particular way of representation is a IP. A copyright or a design registration is an IPR. A brand or a trade name is a intellectual property, and a trademark registration is an IPR. So in this, whatever you see the examples right on your screen, all these are the example of, first example is of this intellectual patent. Second example is a trade secret. Third example is for the trade secret, copyright, and the trademark. So these all examples I have covered in this intellectual property right, and so that you will not get confused about the what is the IP and what is the IPR. So I think I repeat once again, IP means the intellectual property. This is what my individual, correct. And IPR means the Indian government, and the IPR gives me a protection for the, it gives the rights for me to maintain a confidentiality, to maintain a secrecy in my intellectual property. So this means the IPR gives us a right to maintain a confidentiality, but 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 it don't give, but it does not stop a transgressor. It does not stop a transgressor. So the transgressor means what? And how this intellectual property law works, it is an affirmative right. It is not a protection. It is an affirmative right. It is not a protection. And it allows the owner to file a lawsuit against a transgressor, and it does not stop a transgressor. Okay. So talking to more about this, what is transgressor means, I just give a one simple example for this. If I develop and if I patented something suppose a tube I patented and extracted the manufacturing, but we know that these things very well. So somebody else in the competitor will make a copy of my product and start the production in the lower price, because that X company is not invested so much things in the research and development and in the filing the patent. But so then how we can move further with such an example? So this the X company that I told you, which is a manufacturing copying by copying my product and he started the manufacturing, is basically called as a transgressor. Transgressor means a violation. The who violates the law. Correct. So in that case, the what is my rights then? If I file a patent, then what is my rights? How particular that this condition? So this is the if anything problem is there from my end.
No, sir. No, sir. You continue, please.
Okay.
Sir, there was just one request. If you could go in for the slideshow, please.
Is it okay, sir?
Yes, sir. Thank you.
Okay, sir. So I'm talking about this transgressor. So the transgressor means the basically who breaks the law, who violates the law. Okay. So in this case, what is the options that I have to go or I have to deal with such a condition? In this condition, this IPR gives me a right to file a lawsuit against them. Correct. But IPR doesn't have a look into the matter who is going to copy my product. Okay. So this is not a duty of IPR. So IPR gives you a right to file a lawsuit against them. But IPR doesn't control the making a copy of your product. So it is your individual duty to search in the search in your nearby or in your competitor who is making your product copy, and you have to file a lawsuit against them. So in such a cases, this IPR gives you a right to file a lawsuit against them. But meanwhile, it does not stop a transgressor. So here, so this intellectual property rights vertically divided into the two categories. So the first one is the industrial properties and second one is the copyright. So in the just a minute, I have to make some arrangement here. Okay. So in the in the industrial properties, so what are the things are covered under the head of industrial properties? The patent, industrial design, trademark, trade secrets, plant varieties, integrated circuits, geographical indicators. And in the heading of this, under the heading of this copyright, it is going to be covered this literary work, novel, poem, plays, films, musical, artistic, drawing, photograph, performing arts, sculptures, and the software. So these two heads are there. Means I talked during the starting of this session. If you have any idea in your mind, so you have to just categorize in which area or in which category your idea is going to be fallen, and depend on that category of your idea, you have to file a copyright or the industrial property, patents or the plays, poem, whatever you have. You just categorize your idea into these things, these types of this intellectual property right, and you have to file a application. So copyright. So this is the copyright law governed by the Copyright Act 1957. So I know that very well. The participant will going to be get bored whenever I talked about this session and the laws and all. But it is, I think it is important for everyone to know about this, how this IPR is going to be developed in the India. And this is how the title of this presentation is the overview on this IPR. So copyright. So the copyright, it is the original literary. It is a dramatic. It could be a musical and the artistic work, as I already told. The computer software, engineering drawings, and cinematographic films and the sound recordings are covered under this copyright. Correct. Then, what does it give this rights to this basic inventor or the original inventor? The copyright rights to reproduce, uh, make a copy, adaptation, and the translation as applicable. The terms usually this copyright having this validity, it is up to the lifetime of the author or until the 60 years following the year of a death of the author. Whatever this earlier thing is there, so this is going to be have this validity of such a copyright. Okay. Then the broadcast reproduction right. So so this example of this broadcast reproduction right is for the 50 years. Sorry. So the broadcast reproduction right, the 25 years performer right, the 50 years. Okay. I will just give one example of this copyright. If I make a one movie in the Tamil language, correct. If I make a movie in a Tamil language, and if I want to make a dubbed, so there are the two patterns. There are the two patterns. One, to remake this movie into the Hindi, correct? To make a remake of this movie. And second thing is that, and to make a dubbing of this, means the whatever the actors, co-actors are, everything is same as the movie, original movie, but I want to make a movie, I want to just change the dialogue of this from the Tamil language to the Hindi. So this is called as the basically dubbing. And remaking means the theme of this movie and the story is going to be the same. Only the actors and the performers are going to be changed, but the language is the Hindi. So in the both cases, you have to make you have to take a prior permission of this the person who is make a copyright of that thing. Are you clear? Are you getting my point? So the original inventors means that is what the broadcast reproduction right means. And meanwhile, the somebody have this. The Indians are the very talented one. And if you want to make some changes in the movie, and you told that, so I have made so many changes, and this is what my new invention, and this is what my new copyright. In that case, also you cannot allow to file an application under the copyright. To make such a changes also, you have to make a prior permission from the original copywriter, original author. So this why this in the India the laws are going to be changed by the time. And these author's rights are these are the moral rights. This is the authorship object to the alteration. Here you will clear the idea about the alteration. Means you cannot make a single changes into the original original work or the original copyright unless and until you make a permission from the original author. So here are the few example of this literary work, musical work I mentioned here. A literary work means a novel, a diary, poems, etc. Musical work is the symphonized, jazz, improvisation. Then the choreographic works is the dance, the ballet. Artistic work is the painting, engraving, sculpture. Architectural work, the buildings themselves. Then the figurative work, the map, drawing, and the charts of a scientific nature. Cinematographic works in the movies, videos, and the photographic work is the photograph. The program work is the computer programming that we know. It's taking a too much time to go for the next slide. Okay. So this is what the main, I want to just focus on this copyright. So you just try to get this thing. Okay. So just last to last slide, I talked about this alteration in the work. Correct. That alteration in the work is technically called as the derivative work. Derivative, we know that in the mathematics, how we get the derivation from this original equation by dt or means the original work, a derivative work means a work created by translating, arranging, musically transforming, or dramatizing, cinematizing, or otherwise adapting a pre-existing work. Correct. It is called as the derivative work. Means, for example, you can translated work. You cannot make a translated work. Arranged work. Arranged work means you have to just if the my sequence is from A B C D E and you develop in the sequencing by maintaining the B, E, M, F, likewise. You are going to just rearranging this. So this will not, this will going to be covered into the derivative work. Then transform work and the adapted work. To exploit this kind of the work, the authorization must be obtained from the copyright owner of not only the derivative work, but also of the original work. Are you getting my point? So if you want to do such a thing also means if you want to make a one derivative work from the original work, in that case also you have to make a prior permission from the copyright owner. Okay. So the things are there again by which we can make a derivative work, but the uh, in other way, and that other way is the this compilation work. Okay, so this compilation, and these are not basically falling with the term of the databases, which constitute the intellectual creation by reason of the selection or arrangement of their material. So for this, the example is the periodical databases and the audio visual work and the web pages. Okay, for your college site also some website is there. Okay, and we know that for the college site, so basically we have about principal message, HOD's message about this trust information is there. If I make any on the other website which is looking similar to you, but the if the tabs are in the this row wise, I make this tab in the column wise. Okay, I'm just rearranging the tab. The tab information is the same. Only this location of the tab, if I'm going to be changed, it is also part of this derivative work, but it will not going to be covered into the first type, that is the derivative work. So it is called as the basically a compilation. It is called as the compilation. But general speaking, this is also a derivative. Okay. So in such cases also, if you are going to be worked out with the derivative work or the compilation, you have to make a prior permission. You have to get the permission from the original owner of the copyright. Correct? Huh. So this is also important to discuss. I talked about this. Participant will get bored into whenever I talked about this section, rules, and the laws. Okay, even if I want to talk on this. So India has a very strong and the comprehensive copyright law based on the Indian Copyright Act 1957, which was amended in the 81, 84, 92, 94, and the 99. Okay. This amendment word I will tell you. Amendment means the addition of one extra law or act into the previous act. That is what basically called as the amendment. Correct. So the law is copyright law is from the 1957. And basically, I want to talk on this. The area is the why this amendment is necessary. Correct. Why these amendments are there, and what are the causes and what are the reasons arises. So we have to go for this amendment. Okay. So in the 1957, we were very known to the conditions of our country. There was not a mobile phone or the television in the 1957. Correct. And if you want to make a copyright for the broadcasting of my serial TV serial or the picture or the any short film that I make. So that 1957 Act is not going to be capable to get a copyright for my such a this TV serial and my cinematographic work, because in 1957 it was not included, because in 1957 the televisions was not there in India, correct? And broadcasting channels were also not there in India. So then how to cope up with the latest trend in the technology with our law? So that's why these amendments are necessary. Correct. This amendment in the 1994 were a response to a technological changes in the means of a communication like a broadcasting and the telecasting and the emergence of a new technology like a computer software. So that's why the amendments are there in the Copyright Act 1957. Okay. After that, in 1999, amendments have made the Copyright Act fully compatible with the trade-related aspects of intellectual property rights. That is what, in short, called as the TRIPS. TRIPS means the trade-related aspect of intellectual property rights, uh, and it is a fully reflects the Berne Convention 1886 and the Rome Convention 1961. With this amendment, the Indian copyright law has become one of the most modern copyright law in the world. Okay. So here I will go in back in the history for this. Okay. So these conventions are there. So these are in the 1886. 1886 in the Berne Convention and the Rome Convention was in the 1961. So 1886 Berne Convention, what happens in the Berne Convention in 1886? Correct. In 1886, we do not have a laws and all. Correct. But at the same time, the Switzerland, modern developed countries are uh, they are writing their laws in the 1886. But you just imagine what we are at which level in the 1886. Correct. So there are the few terms are there in the, there are the so many conventions, the Paris Convention, Berne Convention, Rome Convention, so many conventions are there. I will not go deep into that, but I just want to tell you, so what are the basically this Berne Convention and the Rome Convention. So in the Berne Convention is talk about if I make a one song, if I make a one song, correct? So this copyright goes to me only. I am the individual person. But what this Rome Convention talk about this in 1961, if I am the song, if I am having a copyright, but what about the musicians which are responsible for your songs to be sing, the musicians, the performer, basically the performer, correct? The guitar player is there. So many performers are there to develop a one or to get a one songs to be delivered, correct? So Berne Convention gives the protection for the performers also, not only for this who writes the lyrics and all, but it covers the all performers which are directly involved into the making of that song. So the Berne Convention is about the this is making of this owner of a copyright for my song, and the Rome Convention is for 1961 is for the all performers who are involved into making that song. Correct. Means the if we talk broadly about this Berne Convention is about somehow this is narrow in the nature, but this Rome Convention is give the broad area so that the all performers are going to be covered into this. Correct. Then what we are doing in this? So how this India is going to be adopt these things? Okay. The adoption of this copyright is like that. So we are going to, so we do not have such a convention and all. Indian convention is not there. Correct. So, and if you want to, so in the, there is also one point why this need is there in the 1999, because it's global economy to sustain into the global economy competition, correct? So we have to make a such a strong copyright law into the India so that this investor will attract, correct? And why such a need to be there? What I just give a review about this Paris Convention. in Paris Convention is 1883. Just 10 years of before 10 years in the 1873, what happens? There is a one conference or this you can say that the project competition or the project exhibition is there. Those who have a novel project, a unique project. So there was a one exhibition was planned in the 1973 into the Paris. But you will get the shock about the information which I will share. So nobody will get a participate into Paris convention, Paris exhibition. Then they searched it out. What is the reason behind that? And they came to know that so the reason is that the zero participant into that project exhibition. So everyone should have a doubt into mind. If I exhibit this my and if I explain my project, somebody will get profit. So that is what the first step in the Paris Convention is that in the 1883, after 10 years of that exhibition, they found the Paris Convention, and that is what this IP. That is what this that is what this patenting rules and all. Okay, so that I called you. So everyone will have a doubt into mind. So what is if I disclose? If I disclose to somebody else, what is my idea? There is a probability of the making of your product and the making of your copy of your product methodology, anything. Everyone have a doubt into mind. So in 1999, what happened? If you want to make a foreign investment into the India, so they should have security. They should have a sure that our formula will not going to be disclosed to the anybody. So that is what it is called as the TRIPS. That is what it is called as the TRIPS. And meanwhile, India have developed on a copyright law in such a way that we are going to just make a copy of this Paris Convention. We are going to make a copy from this Bern Convention, Rome Convention, and the another is also Madrid Convention. हम लोगों ने क्या किया है सिर्फ जितने भी ये सब कन्वेंशंस थे लाइक बर्न पेरिस मैड्रिड एंड ऑल we are just making the copies the law from that, and we are going to develop our own law. So meanwhile, what happens to our copyright law? So by covering the all convention from the worldwide to the one copyright act into the India, so it is going to be most powerful copyright law into the world. So that is what everyone will have a faith into this copyright law of this Indian patent law, IPR, and we know that how this the so many companies are going to be investing to the India and start the manufacturing because of that security given by this copyright law to the uh, this original work and the original company which is outside of the India. Correct. The second term into this next type is the geographical indication. So the governed by the geographical indication of a goods and the registration and the protection act 1999. Okay, so in that what happens and what the things are going to be covered. So I think the geographical indications are the indication used to identify the agricultural, natural, or the manufactured goods originating from a definite territory in the India. It should have a special quality or a characteristic or a reputation based upon the climatic or production characteristic unique to the geographical location. Okay. So example of this is there are in India so many examples are there, but I just come up with some few examples. That is we know that this Darjeeling tea is the famous in the India. Then the Kanchipuram silk saree, then Alfonso mango in the Maharashtra of the Konkan region, then the Nagpur orange, Kolhapuri chappal, Bikaneri bhujia, etc. There so many examples I already talked about. Correct. Only few of them I included in the PPT. So then what happens to this if I am from this coastal area from the Maharashtra, from the Konkan region. So you will find on the map, on the Maharashtra map, on the Konkan region, you will find a logo of this, a photo of this Alfonso mango. Correct. From the Nagpur, it is going to be have this orange. From the Kolhapur region, you will find a Kolhapuri chapel, Bikaneri Bhujia, likewise. So the any association of a person, producer, or the organization established by or under the law can apply a representing and the protecting the interest of the producer. So if I file a copyright for a such a case, then if I file a copyright for a such a case, then what happens? Okay, so it first of all you have to office will scrutiny your application and they check the validity if it is valid or not, and after that it gives your this registration under the geographical indication for a period of a 10 years. So once these 10 years are over, then you can renewal is possible for a further period of the 10 years each. Okay. So this is all about the geographical indication. Then, then the protection of a new varieties of a plant. Protection of a new varieties of the plant. The objective of this act, the objective of this act are the following: to provide for the establishment of an effective system for a protection of a plant varieties, to provide for the rights of a farmer and the plant breeder, to stimulate the investment for a research and the development, and to facilitate the growth of a seed industry in India, to ensure the availability of a high quality seeds and the planting materials of a improved varieties to the farmer. So for this protection under this plant varieties, okay, and the law for this is established in the 2001. Okay, in India, so there so many things are going to happen in the tissue culture. So the means basically this is I'm talking about this. This is in the fold. This is in the tissue culture. The so many plant varieties are going to be manufactured by the breeding of this different seeds to into the one seed for the production for the any kind. In that case also you have to go for this protection of a new varieties of a plant under the 2000 the protection of a plant varieties and the farmer right act 2001. Yeah, with the help of this law you are going to be have this protection for your new variety of the plant. Then for the electronic students and for the electronics and the electrical, so we know that so many this electronic things are going to be changed in the worldwide and in India also. In that, there are the the laws are there in the to be governed by the Semiconductor Integrated Circuit Layout Design Law, that is basically in short form called as the SICLD Act 2000. So in that, what type of this protection is given by this law? So this is the governing act for a layout design of an integrated circuit in India. The aim of this act is to provide the protection of intellectual property right IPR in the area of a semiconductor integrated circuit layout. The act is implemented by the Department of Information Technology under the Ministry of the Information Technology. The Semiconductor Integrated Circuit Layout Design Registry is the office where the application on the layout design of an integrated circuit are filed for the registration of a created IPR. The registry has a jurisdiction all over India. So jurisdiction for the jurisdiction, I will tell you the things are how this jurisdiction are going to be covered in the second part. Okay. So this for the layout of this integrated circuit, what happens if I want to make some anything which is going to be make a automated. Okay. We know that this fan is going to be operate with the help of the this controller. Okay, and if I want to just make a by just switching of my moving of my hand like a gesture, I want to control it. For that we need to I need to go for this different kind of this different kind of microcontroller integrated circuit and all. And for that I have to design one PCB, basically a PCB. For that unique PCB for your time, You have to make a design, you have to working it out, and if everything is fine, you have to file a application under this SICLD Act, and you will get a patent for that. Means nobody will make a copy of that and start the same production of your product. So that's why it gives you accuracy that you are going to be file a lawsuit against it. Then lastly, the trademark. So this is known to everyone. The trademark means why the trademark is there basically. Why the trademark is there? So everyone will know about your product. Everyone will know about your product by seeing a logo. By seeing a logo. Here on the screen, you will find a logo of the Sony camera, Olympus, and and we know that for the car also we know that the T is for the Tata, S is for the Maruti Suzuki and all. There are so many examples are there for the Coca-Cola bottle, the Coca-Cola, the pattern of that Coca-Cola, that is the spelling in what manner it gives this Coca-Cola. So this is also going to be under the heading of this trademark. So trademark is any sign which can distinguish the goods of one trader from those of another. Sign includes the words, logos, pictures, or a combination of these. Okay. So means this trademark will include, this is the important point, trademark includes the word, logo, picture, or a combination of these. Okay. A trademark is used as a marketing tool so that the customer can recognize the product of a particular trader. To register a trademark, the mark must be distinctive and not deceptive or contrary to a law of a morality, and not identical or similar to any earlier mark for the same or the similar goods. Means basically, uh, it should not get a copy from the original one. So that's why. So you will find so many such things in your day-to-day life also. For the Reebok shoes, you will find there is a one slight spelling mistake into the Reebok shoes. If you want to make a copy, so they are intentionally make some mistake into that Reebok logo or into the spelling of the Reebok also. So such a thing you have to get a notice whenever you are going to design. The trademarker. The India offers a full protection to the trademark under the Trademark and the Mercantile Act. The Indian law of a trademark is protected by the Trade and the Mercantile Mark Act 1958. A new statute, that is the Trademark Act 1999, has been enacted in India to bring it in a conformity with the TRIPS agreement, okay, to, to which India is a signatory. Indian Trademark Act 1999 came into the force on the September 15, 2003. Okay, so here will question will be there. So the TRIPS is there. I already talked about the TRIPS. This is about the trade secret, correct? So India is the signatory country. Means what is the TRIPS? TRIPS is the worldwide one organization, and every country has to be. This is on the willingness of that country. You have to sign that TRIPS, and under that TRIPS, you have to follow certain rules are there. Okay. So these rules are new. Again, it is a very difficult to implement these rules to the country for the other countries. Okay. In that case, what happens to this? The TRIPS gives the 10 years of the time span to the underdeveloped country like India. तो आप लोगों के पास 10 साल है, तो 10 साल में आप लोग स्टेप बाय स्टेप लॉ इन्फोर्स कीजिए आपके कंट्री में. Okay. So and India take advantage of that 10 years, and India make a very strong trademark, very strong law like a copyright into this trade with the help of this trade. So India has made a step towards the fulfilling its international obligation. Consequently, the Indian trademark law has now become fully compatible with the international standards laid down in the TRIPS agreement. The new act primarily consolidated and amends the old trade and the mercantile Mark Act the 1958 and provides for a better protection of goods and the services. So here is the one design act. Another part is for the design act. Okay. You are able to see on your screen. It is applied to any article of a manufacturer in a two dimension or the three dimension or in the both form. Okay. So design act gives you the you just see a jar into the on the second diagram. You just see a jar. Okay. So this electrical jar. Okay. Then what type of the protection is given? You will receive uh, if you file a if you file application under the industrial design. The protection you receive is only for the appearance of the article and not how it works. Okay. तो इसमें वर्किंग का कुछ सीन नहीं है, इसमें सिर्फ क्या है, जो aesthetic लुक है, जो appearance है, the appearance will give you the right under the industrial design. The design registration is intended to protect the designs which have an industrial or the commercial use. The duration of a protection is initially for 10 years and extendable for another term of 5 years. Design of a stamp, labels, token, card, cartons, or a part of an article not sold separately cannot be registered. So here the 15 years ago, the company's competition is based upon the price. Right. The today the competition is on the quality and the tomorrow it will definitely on the design. Even it is just beginning of that design part. I will give an example of the car. Okay. Uh, just 10 to 15 years back, I think nobody will know about the crash testing will be there for the car. But nowadays, everyone see whether this car is safe for rating for this car safety 5 star, 3 star, or the 4 star. Okay, so this now the world is about the design. We are ready to pay an extra cost if the car is more safe. So I will give you an example. If one X manufacturer is there, the crash test result is a 1 star with the 10 rupees cost. This is for understanding only. And Y manufacturer is there, okay, and crash test result is the 5 star and the cost is the 15 or the 20. So today, which car you are going to be buy? So personally speaking, for my personal opinion, I will go for the car with the 5 star rating for the safety with the 20 rupees cost. So this is all about the design. So this is the full fruit basket design. This is the cross. This is the cross lines are there. Okay. So anybody will make with the straight line of this crossbar also. But this is what the pattern of the basket is going to be designed. Pattern of the pattern of this fruit basket is going to be applied for this under the designer. In the classification of the design. Okay. So here in the design, the class 01 is there. That is the food stuff that I just told you. The subclass 1 of 1 is the baker's product, biscuit, pastry, and the chocolate. Subclass 1 of 4 is the meat and the fish. Subclass 1 of 6 is the animal food stuff. So in this way, you can subclass the each and everything which are going to be used in the day-to-day life and used with the help of your food stuff, that is the class 1. मतलब ऐसा है कि कोई चीज़ आप लोग बना रहे हो, ऐसे कुछ फ्लैट है, उसमें आप लोग क्या क्या रख सकते हैं, उसमें सब क्लास भी डिफाइन कर लो. Yes, ma'am. Is there any problem from my side? Please let me know. So design, the existing legislation on the industrial designs in the India uh, in India had achieved a mature status in the field of industrial design, and in view of globalization of the economy, the present legislation is aligned in a view of the changed technical and the commercial scenario and made to conform to international trends in a design administration. So it is again the two things are there. The first one is the trade, and second one is the WTO, World Trade Organization, and the trade. So the in the both this organization, India is the assignee of this. So to make a international competition and international trade in the design, so this act is a new Design Act 2000, where new act Design Act 2000 were there in the India. Uh, So here I will come up with the one trade secret related one example. So a typical example is the Coca-Cola. This soft drink was invented in 1886 and was never protected by a patent. So you will get a shocked about this information. Since 1886, the Coca-Cola started the production. Still, it is going on date in today's date, but that was never been a patented. Only there is a trademark. Trademark is there. Trademark means this Coca-Cola design, the Coca-Cola writing pattern is going to be get a this secure under the trademark law and by an industrial design. Okay. So there are the only two things is going to be covered. The first one is the logo of this Coca-Cola under the trademark and the shape of the bottle or the design of that bottle. And you never, I think you never thought about the shape of that bottle. And this shape of that bottle is supposed to be in the shape of a woman wearing a long skin tight dress. So the only two things is going to be covered: bottle design and the trademark only. Then what the things are there, this Coca-Cola makes unique through the worldwide, because the so many competitors are there like a Pepsi and all, Thumbs Up, but they don't made a same taste as that of Coca-Cola. The process of the Coca-Cola drink is a secret and is only known by a two-person in the world. They are not allowed to travel together, so that there is a no chance there is a no chance of them dying at the same time in an accident. The secret of the Coca-Cola process was well kept during all these years, and nobody is able to produce a drink with exactly the same taste till today. You all know that the Pepsi Cola is the biggest competitor, has a different taste for this Coca-Cola product. Then the patent. So we have a separate section on the patent. That's why I'm keeping this slide. Okay. So example of this CD player. So in the CD player, this is a famous CD player. So CD player, the industrial design protection of for the 3D shape. So whatever this outer shape is there, it is going to be covered under the Industrial Design Act. Okay. The music played on the player is protected by the copyright. The various technical part and the mechanism are subject to a matter of a protection under the patent and the brand name registered under the trademark. So the conclusion of this slide is, if you want to make a one product into the market, so there is not only you have to file only a patent or only a design, you have to go through the each and every aspect of that product which are unique to your individual prototype or individual product. Means like an example of the CD player, the aesthetic look, whatever you feel, uh, whatever you see, it is going to be protected under the 3D industrial design. Then the music played on the player is protected by the copyright. Then the various technical terms means I told you about this integrated circuit layout is uh, going to be registered application under this integrated circuit law. So the various integrated circuit useful for this playing CD, it is going to be covered under that law. And the trade name, that is the Sony, Panasonic, whatever the name or the trademark is there, brand name is there, it is going to be registered under the trademark. Okay. So here I will appeal the participants. If you have any query for this, in this first part of this my presentation.
If anybody having a query, so they can ask.
Okay, otherwise I will start the second session, how to file a patent application in India. Screen is visible to everyone, please, sir.
Yes, sir.
sir,
Yes, sir.
visible.
Okay. So I will start with my second session, how to file filing of a patent in India. Okay, so here I want to clear again another one thing. I am not talking about this PTO. So it means I'm going to talk about only the Indian patent filing, not about the international patent filing. Right. So we know that the intellectual property rights are intellectual property right is have a classification of a trademark, copyright, patent, industrial design, and the trade secret. So out of these three, five we are going to talking about today how to file a patent in the patent of in the India. Okay. The intellectual property is a literary, artistic work and the industrial property. And intellectual property right, that is IPR, protected by a copyright, protected by a patented object, design, layout, design, geographical indication. Okay, this is what the reference from my first previous slide. The patent. A patent is an exclusive statutory monopoly right granted for a limited period of a time to the patentee by the government in exchange of a full disclosure of its invention. Means there, so this will not be the case. If you don't disclose the anything what is going to be invented by you, then the government will not give a patent right. Okay. So the patent is an exclusive statutory monopoly right granted for a limited period of a time to the patentee by the government in exchange of full disclosure of his invention. So once this final is grant is there, you will find a certificate like this. Then, so if you have any idea in your mind, so how these things are going to be done and how we are going to be checked whether my idea is patentable or not. This is the very first big question to everyone. So you have to just simply go through the three steps. The first step is your idea should be a very novel idea. Then the intentive step and the non-obviousness. Means it should not have a non-obviousness into this and the industrial application. Means the first your idea should be a novel. Novel means यूनिक होना चाहिए. Okay. यूनिक मीन्स किसी ने ऐसा कुछ किया नहीं है सबसे पहले वो चीज आप लोग कर रहे हो. It should be a novel of the unique. Second is the non-obvious. So non-obvious means suppose this is the bottle. This is the bottle. If I free this bottle from my hand, it will fall onto the ground. Or simply if I open the cap of this bottle and tilt it, after that the water will flow onto the ground. So these are the obvious things. Okay, these are the obvious things, and you will not get a patent of such a thing. Means if I fall from the building and I will fall into the ground. You will not get a patent for such a case. Means it should have a non-obviousness into this. So this is what the means the intentive step would be there, innovative step would be there. The second stage, and third, it should have an industrial value or it should have a industrial application. Only the three steps are there: novel, non-obviousness, non-obviousness, and the industrial application. The three things are there that you have to set your idea with such a three steps. And if these three steps are if three steps are the clear, then nobody will decline your patent to get a grant. Then, so if your idea is there, any idea is there, and how you are going to be checked whether this is the patentable or not. Correct. So which things are the patentable? There are the very wide scope for that. So that's why we talk on this, the things which are non-patentable in India. And apart from this, everything will be going to be included into this. So the things are not patentable in India. A scientific principle or the formulation of an abstract theory, any new property or a new use of a known substance or the process, machine or apparatus, unless such a known process results in a new product. Correct? The the mere arrangement or the rearrangement or the duplication of a known devices, each functioning independently of a one another in a known way. This is also not going to be covered into the Indian patent law. A method of agriculture or the horticulture, invention relating to the atomic energy. So these things are not going to be covered into the invention, and these are the very generic ones. You are not able to file a patent in for such a application, okay, or such an idea. Then, so who is going to be file of application? So this is the another step to be discussed. Now, who is going to be file a patent in patent application? By any person claiming to be the true and the first inventor of the invention, he is going to be file a patent application. Same. The second type, by any person being the assignee of the person claiming to be the true and the first inventor in respect of the right to make a such an application. Same. The third type which falls into this category, by the legal representative of an deceased person who immediately before his death was entitled to make such an application. And the last one is by the legal representative of the true or a first inventor with the power of authority signed by the inventor. Okay. So let me clear the things of little bit few words or law kind of these words are there into this slide. It is a mandatory to mention it according to the law. So in a very simple way, कि कौन file कर सकता है application eligibility. The first and the true invention means if I have an idea and which is going to be passed to that 3 points, then I'm going to be fine. So individually, so whatever I talk is initially give my introduction. We said that the 17 patents. So all 17 patents are prepared by me and filed into this Mumbai office of this Indian Patent IPR. Okay. So if you have an idea, you can individually file a patent into this patent office. Correct? Means any person by that's why the first step and the first point I mentioned by any person claiming to be the true and the first inventor of the invention and rest of it. And then apart from that, the if personally I'm not able to draft this patent application, and somebody else is going to be have this patent agent and all. I will give power of attorney to power of authority to that law firm of the particular patent agent, and on the behalf of me, he is going to be file a patent application. Okay. Then a step in the filing a patent application. So the first, the invention, then the filing a patent, and last, inventorship rights. But uh, I just get a unknown here. This is the invention, correct? Invention, filing a patent, and the inventorship rights, correct? But you will find a very three steps: invention, filing a patent, and the inventorship rights. But in the filing of the patent, you will find a territorial jurisdiction. First, you have to find out the territorial jurisdiction. after that, after that, there are the two options are there. First, either you have to file it individually or you have to file through a patent agent. Correct. After that, if you go for this any one of this, either from the patent agent or from a individual application, but you have to go for some basic information. First, invention disclosure. Invention disclosure means you have to just simply write what is your invention and all. And after that, you have to search for this patentability. Whether this is going to be patentable or not, you have to search patentability. Then after that, drafting a patent application. Drafting a patent application. Again, you have a you have this two options. Either you have go for the national filing or the international filing. I think this is a clear to all of you. So I will just review this slide once again. So there are the basically three steps are there. So the first one is invention, filing a patent, and at the last you will get a grant. But into the this filing a patent, first of all you have to sort the territorial jurisdiction. I will going to be come up with the next slide. What is the territorial jurisdiction in India? Then after that, you have two options. Either you have to go for the filing individually or file through a patent agent. So you choose any option, but after the by choosing the any one option from these two, you have to you have to disclose your invention, search for the patentability, and draft the patent application. And lastly, you have two options. Either you have to file your patent application for the national filing or the international filing. So this is the basic information. This is the basic information for the filing a patent. But as far as this exactly this application is concerned, here we are going to start with the step one. So in the step one, you have to just finalize or you have to sort the territorial jurisdiction for your area. So this territorial jurisdiction in India means place of a residence, domicile or the business. Okay, place of a residence. So suppose if you have a company, means then the company address or your business, or your if you are a individual filer or individual filing, you have to get the information about the residence domicile for your applicant for the applicant. Then place of actual origin of an invention, then the address for a service in India. Then here are the territorial jurisdiction in the India, and here on the left the patent office. For the state of Gujarat, Maharashtra, Madhya Pradesh, Goa, Chhattisgarh, and the Union Territory of Diu, Daman, Dadra, and Nagar Haveli, the patent office is the Mumbai. For the Delhi, for the patent office for the Delhi, the state of Haryana, Himachal Pradesh, Jammu Kashmir, Punjab, Rajasthan, Uttar Pradesh, Uttarakhand, National Capital Territory of Delhi, that is the NCR, and the Union Territory of Chandigarh are going to be covered into the Delhi Patent Office. Okay. Then the state of Andhra Pradesh, Telangana, Karnataka, Kerala, Tamil Nadu, and the Union Territory of Pondicherry and the Lakshadweep is under the Patent Office of the Chennai. And for the Kolkata Patent Office, the rest of India. So whatever these are not mentioned in the Mumbai, Delhi, and Chennai, all are going to be covered in the Kolkata. And these states are the Manipur, Tripura, Nagaland, Arunachal Pradesh, West Bengal, Sikkim, Assam, Meghalaya, Bihar, Orissa, and Union Territory of Andaman and the Nicobar Island. So this is the territorial jurisdiction. As far as this today's all participants are concerned, we are under the head of this patent office in the Mumbai. Then Step two, the patent attorney, patent agent, and the patent lawyer. So who is going to be file a patent with the help of? The person registered to practice before Indian Patent Office. The Indian patent law specifically does not mention the designation of a patent attorney. Okay. The Indian Patent Office conduct a qualifying examination for a patent agent registration yearly. So with the help of this, by clearing the exam, you will simply become a patent attorney, patent agent, or the patent lawyer. Correct. Then what is the difference between the attorney, agent, and the lawyer? For the patent attorney, the applicant must have a degree of a law, and he is registered under the any bar council of the India. Then the patent agent. So who is going to become a patent agent? The condition for the patent agent is that he or she should have a degree in the science and the engineering. Then and then only you will become a patent agent. And the patent lawyer is the simply it possesses the degree of a law. Correct. And these three must have a pass the examination which is going to be conducted yearly by the Indian Patent Office. So you people have a three options, four options personally speaking, by which you can file application into this for the patent attorney, patent agent, and the patent lawyer. And the fourth option is individual. Then the invention step three. Step three is the invention disclosure. The disclosure of the invention by assigning a non-disclosure agreement. So discuss this invention in the full detail, that is the description, diagrams, and the experimental result if there is any. Means for filing a patent, you must have the prototype is necessary. Means not only this intangible, if idea, we are not going to be file only just idea. You have to make a prototype of that idea also. Means the tangible and intangible, the both things are necessary in to file a patent. Then how we are going to be search this patentability search, that I already mentioned in the slide, that if you have an idea, you have to first of all disclose your idea, write it down, and after that you have to search the patentability. Okay, this freedom to operate a search, that is called as the FTO. Okay, these are the so many. You just Google it. How we can going to be search the novelty. Okay, personally speaking. You just write your idea into the Google, and if your Google says what did it you mean, then you said that you conclude that this idea is the novel. Very simple thing. Okay, the step is you have to just type on the Google whatever the idea is there, and Google is unable to display the result, then you should come to know that this idea is the novel. But unfortunately, some results are there. You have to open each and every result and find out, uh, read out this all result which are related to your work. And if you find something is different with you, okay, then you are simply go further, simply file a patent application. Okay, and we know that on the Google there will be a very non-productive information will be there as soon as you start the search. So here I will tell you how you people are going to be search the result. Okay, this is not mentioned in the slide so that the participants who are listening to me very carefully, they will get a benefit. Correct. So what you have to do, you have to just simply search a Google patent on a Google. I repeat, search a Google patent on a Google. So there will be a separate window you will find. There will be a separate window like a Google patents, like a Google patents search bar. And into that search bar, you just type your idea. You will find the patents which are already filed similar to your idea, and you have to just read out the each and every result uh, seriously. And if you find anything which is really similar to you, then I suggest you people to don't file a patent. You work on that idea more, and you have to work more, think differently how the same output is going to be get it by the changing the process. Okay, or you have to think further, or you have to think further the next idea or the anything else. But you have, if I suggest you people to don't file a patent in such a case. Okay. Then the novelty and patentability search to determine the novelty and non-obviousness of an invention. So whatever the points are mentioned on this slide, which is visible to you, everything will be going to be clear if you find this similarity. If you find this similarity report onto the Google. Okay. So this is the step number 4. Then the step number 5, what types of the patent applications are in India? So the first is the ordinary application. Just give me a minute. So step number 5, ordinary application. That is in that ordinary application, the I will talk more after this. Okay. Ordinary application. This is what called as the national filing, and the PCT. PCT is the international filing. That is the conventional application. PCT is the international application. PCT national flavor application. Okay. Although I talked initially about I will going to be not going to be talk on the international filing, just one sentence you have to just remember. To file a international patent, it is a mandatory to file a patent in your home country. It is a mandatory to go for the PCT. Then the second type of this application is additional application, means the patent of addition and the divisional application. Okay. So this my core area is about the first, that is the national application. Okay, ordinary application. In the ordinary application, there are the two types. The first one is the provisional application or the complete application. What is the provisional and what is the this complete application? I will tell you. Uh, there are the two terms are there. Idea is in your mind, and second is the making a prototype. Correct. In idea in mind is called as the provisional application, and this is what my this is what my personal this gaining from that word provisional application and all. Okay, and the complete application means in the whatever you mention in the provisional application, and if you make a such a input output everything, you have to make a specific application or the complete application. In that you in the complete application you need to disclose the all technical details related to your invention. Correct. So this ordinary application, provisional application, and the non-provisional or the complete application. Right? It's these two individually, two mergely become a ordinary application. Okay. Hmm. So in the complete application, what you are supposed to be doing? Okay. In the in the first provisional application, you just write down the idea, whatever the idea you have in your mind, that is called as the provisional application. And you come up with after some time, you come up with the complete application or the complete specification. In that, applicant should mention each and every detail related to your patent. Correct. And make sure that whenever you are going to be mentioned such a thing, provisional application and the complete application. So in this between two phase, that is the provisional and the complete application, you will get a time of a 12 months. Okay, means if I file a patent on the first January 2021, then the time limit will start and the time limit will get end on the 31st December 2021. Okay, so you will get a 12 months time period to file a complete specification against your the provisionally filed your application for the patent. In that, there is a one special case also. The extension of the 3 months you will get on requesting you will get. So, but uh, but from my side, you just consider only the 12 months period. Okay. So why the things are necessary to have such a provision in the Indian patent law? What happens this first intangible nature is also going to be covered into this provisional application because so many students are there. If somebody has idea, first of all, I have to reach to the patent office. If I reach, okay, I will tell you one thing. Whenever you file a patent, once it is get published, okay, on your Indian Patent Office site, okay, the time of the date of on which you have filed a first application is going to be displayed with your application details on the date, time, and the second basis. Means here the Indian Patent Law Office works on the first come first serve basis. Okay, means if anything idea is in your mind, okay, so don't waste your next time to making a prototype of your idea. Meanwhile, somebody else goes to the office and file a provisional application. Correct. So such things will not be there. Just I just recall my one. One incident, one experience I want to share with you. I filed a patent on the cylinder emptiness. This is a household cylinder, and I filed it. But once it is get published, after the 5 months of the publication, I got a mail. And this is not a hypothetical thing. If somebody have a problem, I will show you the mails which I have received from that company. The that company is working from the last 5 years on the this my problem. Okay, but they never went for the filing a patent. But I have got an offer that I'm going to be they are willing to get a technical sharing on the same. But once I got information about it is going to be get a patentable, I just reached to the patent office to file application with the complete specification, and my patent get published. But the company which is dedicatedly working on the same product since the last 4 to 5 years, but he doesn't he don't go for this they don't went for this application of file a patent. So the such things will be there in your life also. So it's better to file a patent as early as possible. Correct. Then the conventional application, India is the member of this Paris Convention. Filing of a patent in one conventional country, filing of a similar patent application is in as required another convention countries. Within a 12 months from the date of a filing of the first application, you will have a period of this 12 months to file or to submit a complete specification. And as I already told, I'm not going to talk about this international filing. Huh. So, document required for a filing a patent application in India. First, the application form, provisional or a complete specification. And if the provisional specification is filed, it must be followed by a complete specification within a 12 months, or in bracket the 15 months with the extension, means the 3 months of the extension. Drawing in the triplicate means if there is a necessary to get a receipt from that office, then in that case the triplicate format is necessary. But uh, I filed a 17 patents. I never go for in the triplicate or the duplicate in the format. Single format or the single application is also it is going to be accepted in every office of this Indian patent. Okay, and the abstract of the invention. So these are the documents required for the filing a patent into the patent application in India. Then, after that, the information and undertaking listing the number, filing date, and the current status of each foreign patent application in duplicate. The priority document, that is the priority date is claimed. Declaration of the inventorship, where the provisional specification is followed by a complete specification, or in case of a conventional application. Then the power of attorney, if you want to get a file through the patent agent or the patent attorney, you must have a power of attorney. Then the fee in the cash or the local check or the demand draft is going to be accepted at the Indian Patent Office. So everything which I talked about this is everything I talked is from this references from the official website of the Indian Patent Office. Okay. Then the Indian Patent Office, it is not necessary to you go here in the offline mode, make a print of application and file. So the online application is also accepted accepted into the Indian Patent Office. So, but for that you must have a digital signature, that pen drive of digital signature. On that basis, you are going to be apply for online application of the filing of online application into the Indian Patent Office. So the for this e-filing, you need to have make user ID over there, signing ID and the password. Once it is logged in, you have to just upload the forms. So which forms are need to have? This is the on the display you will find a form number 1, form number 2, 3, 4, 5, 26, 9 and the 20. The form number 1 is for the application for a grant of a patent. Form number 2 is for the provisional or the complete specification. Form number 3 is for the statement and the undertaking under the section 8. Form number 4, declaration as to the inventorship. Form number 5, declaration as to inventorship. Then the form number 26, form for authorization of a patent agent or the any person in a matter or the proceeding under the act. Form number 26 means from on the behalf of me or the organization, if someone else is going to be file a application, in that case you need to have a form number 26. And the form number 9 is for the request for the publication, and form number 28 is for to be submitted by the small entity. But as far as this individual application is concerned, you must have a form number 1, 2, 3, 4, 5, 9 and the 18. So here are the fees of these individual forms are there. So the form number 2, form number 3, form number 4, it is the 1,600 if the individual application, and if the organization is there, the fees become the just a minute. I think so this side. For this form number 1, application for a grant of a patent, the natural person or the individual inventor, the cost is the 1,600. For the early publication, fees is the 2,500. Then the request for the examination of the patent application, 4,000. Then the for every extra sheet over the 36, sheet means the application, the 160 rupees per sheet, and for every extra claim over the 10 claim, the 320 rupees per claim. But if you have a small entity, you just compare the cost. For the natural person, it is the 1,600. For small entity, it is the 4,000. And other than the small entity, it is become a 8,000. Such a means if you want to file a patent with the some organization company, whether this is a small company or the other, so the cost is going to be vary dramatically. For the individual application, it is a whether it is a 1,600. You just imagine for the small entity 4,000, and for the other than small entity, it is the 8,000. In this way, if you want to, you just calculate the uh, you just calculate at the end. I think I calculated it. The 48,000 is the only fees we have to submit to the Indian Patent Office by the organization. If you are the individual patent filer, it become a 10 to the 11,000 fees. Okay, means if or if you are from an organization, if you file a single patent, in that cost, from the individual patent, you are going to file a 3 to 4 patents from that, from the same cost. Then the patent opposition in India, mm, pre-grant, post-grant, grant of a patent. Okay, pre-grant, post-grant. I will tell you some few words. You get a board for that pre-grant and the post-grant. Okay, if someone like me publish a one patent, and somehow this you or the any sir from this participant have a same patent. Okay, in that case, before granting of this patent, you have to just file uh, this application to the patent office that is what is matching to me. So this is called as the opposition proceedings opposition proceedings in the pre-grant and the post-grant. So it's not necessary that for this opposition for the patent you have to just file the into before the granting. No, no, not necessary. If you find once this patent is granted to me and after that you find so this is a similar to me, then after that case also you have to file you have to file a opposition process opposition or file a application against my grant. Okay, so that is what is called as the hearing. So the it's just like a law. So then where this hearing will be done, so the hearing will be going to be completed into the territorial jurisdiction of a law and the high court or the court. Okay, either in the district court if you are belongs to the high court, then the high court, or there is a one board of this intellectual property board. Okay, on that board. So three options are there: district court, high court, or the authority board of this Indian Patent Office. I don't know the exactly name, but the board of authority, likewise the name is there. Okay, so that is what is called as the patent opposition in the India. Pre-grant, post-grant. Okay, and these are the patent office procedures and some laws are there for this Indian Patent Act 1917 and all. Okay, and here are the references from the ipindia.nic.in, then the wipo.international and ssrana.in. Okay, so see here I get the information from this, and here I will say a thanking to the all participants for listening to me very carefully. And here I will ask you if there is any query for any participant, please let me know. Or you just type your queries into the chat box.
Any queries? Participants, if you having any queries, doubts about IPR, so you can ask.
Thank you, Rashmi ma'am. Thank you, Swati ma'am, for your comment. Please, if
Thank you,
any,
sir.
Thank you, sir.
so I think I will just check the my chat box if there is any question from anybody.
Yes, yes.
Thank you, Avinash sir, for a nice comment. I also thankful to the Praveen Kumar. The two new
Okay.
messages. Thanks for the informative session. Okay. So thank you everybody who comment for this session. But I really happy if you text me any query for this. I really cover the each and every aspects of this filing of a patent into the India. I hope there will not be the any query from anybody. So here I will get this information. I will hand over this session to the sound sir, who is going to be take over.
Thank you, sir. If we are having any queries, so we will forward to you.
Okay, sir. So here I will get a thankful to the management of this college, principal sir, and the organization committee of this national level seminar. I will very grateful to have this session with you people. and I hope in future also there will be the initiation from your side. I will be very happy to conduct this session. Okay. So I thank you to each and everyone which are connected through directly and indirectly to organizing this national level seminar. Thank you everyone.
Thank you, sir. All of us got the stream of knowledge from your keynotes. Now it's time for the discussion, so no one is here to ask the queries. Anjane, sir?
Vote of thanks.
Okay. Now I request Dr. P.R. Mahajan, sir, to express the vote of thanks.
Thank you, sir. Good afternoon, everybody. I thankful to Honorable Principal Dr. J.B. Anjane about holding the post of the President of today's national seminar on intellectual property rights. I also sincerely thankful to Professor Dr. Vikram Swarnakar sir, deliver very nice lecture, very informative lectures on the topic of intellectual property rights. He briefly explained what is intellectual property, how it is work. He also aware about the Copyright Act related to the IPR. He aware about the how to Indian patent file. This information will be of great use in the future. Now I thankful Dr. K.G. Kole, convener, and Dr. S.N. Vaishnav, coordinator of this national seminar on intellectual property rights about good management. I also thankful to Honorable President Bhagwat Patil, Honorable Chairman Siram Patil, Honorable Secretary Sanjay Patil, and members of the Ainpur Parisar Shikshan Prasarak Mandal to support and guidance for organize today's national seminar. I also thankful to Honorable Principals of various colleges, professors, participants, students for your join, and today's event is success. I thankful all committee members, teaching staff, non-teaching staff to cooperate for today's event. And note for the important note for the participant. To get the e-certificate, you have fill up the feedback form uploaded on the WhatsApp and Telegram group. With the prior permissions of the Honorable President, I declare that the inaugural program is over. Thank you. Thank you very much.
Thank you.
Thank you.
एंड करायची ना सर